somebody sends a message, making sure, well, hang on. Hey, it says my broadcast has started, so I hope I'm not messing this up. Good afternoon, everybody. I'm Justin Schuhmacher with Indiana Estate and Elder Law. If it would be okay, maybe somebody send me a quick message to make sure that they can hear me loudly and clearly. I want to make sure that that I don't screw up the technology. How about that? Okay, perfect. I got a message. So what we're going to do today, I am an attorney. So luckily I'm not in person. So when you hear that an attorney is speaking, you can't throw something at me. I guess you're just going to damage your own screen and computer if you do that. But we try to be the good kind of attorneys that try to help bring some peace of mind to people. This afternoon, we're going to do a very quick presentation called 5 Components of a Comprehensive Estate Plan. I'm going to try to get my screen shared so you can see my presentation as we go. And hopefully we got that going for you. All right. So with that being said, let's go ahead and get this started once. Well, it's doing that. So as I said, I'm Justin Schuhmacher with Indiana Estate and Elder Law, and I know I'm talking to some retired teachers this afternoon. Just give you a little bit of background about me before we get going. But again, our presentation, 5 Components of a Comprehensive Estate Plan. I'm going to try to get through the presentation so that we can leave some time for some questions. I know we have a hard stop here in about an hour, and it'll probably end the session. So I doubt I'll be able to adequately answer some of the questions you put in the chat. So I want to leave some opportunity at the end so I can go back and review those before our time is up here. Really quickly about me, about our law firm. I'm in Fishers today. Our main office is in Fishers, Indiana. We also have an office out in the west central part of the state in Rockville, and also in Wabash, Indiana, which is where I'm going to be tomorrow. Indiana Estate and Elder Law was previously Hunter Estate and Elder Law. We've been around since 2001. I joined the firm about 5 years ago after a career in teaching. I was actually a high school economics, government and United States history teacher, and I've gotten to know some folks involved with the Indiana Retired Teachers Association over the past year. We did a really cool circuit of presenting to the various regions throughout the state, and that was really exciting for me. I had a great time meeting a lot of wonderful people. So yeah, in a previous life, I was a teacher. I like to think of myself as a teacher at heart still. I'm still just as cynical towards attorneys like anybody else. But with that being said, in the picture here, you see me, and also my wife, Jenny, who is also the other partner with our law firm. She's the one that actually brought me on board with the firm. And we like to say we do peace of mind law. We try to be the attorneys that keep you out of court and keep your families out of court. Because if you build a comprehensive estate plan and cover all the bases, then most of the time we don't have a whole lot to worry about as we travel through some emotional and difficult times when things change in our situation or if our loved ones pass. So I'm going to promise you a couple things. I'm going to promise you that I'm going to throw a lot of information at you. Some of you that maybe have attended the in-person sessions, you're going to hear a lot of the same material, but maybe and hopefully you'll take some new piece of information away. In the event that you don't, I guess, sorry, but for the most part, we hope that you get some information that can be useful to you. So I promise you the time's going to go fast. I'm going to go through a lot of information at you, but I asked for a promise in return. If there's a way that you can provide us a little feedback, either through those that have coordinated the event or anybody else, if you want to contact our office directly, if you have some feedback or ideas, more information or new information you'd like to learn about, I ask that you promise you'll let us know. So with that being said, I know I mentioned our office is in Fishers. We have an office in Rockville. We have an office in Wabash, but just like anything else, we are able to accommodate you wherever you are in the state. So I always like to throw this little cartoon up there. Those of you that are familiar with Zoom, I think it's kind of funny how Zoom is, my joke here is like a modern day seance. It's one of those when you're trying to sign in, we can hear you, we can't see you, and those sort of things. But we can accommodate you no matter where you're at. Certainly there's a little bit of info on us. You probably don't care about that. You care about the material. So let's jump into those pieces of material right now. So as we think about an estate plan, and I'll jump through that. As we think about an estate plan, I'm always going to start with, there's a few items that I think are the building blocks of all estate plans. And those are the first three items on this list: a power of attorney, a living will declaration, and an appointed healthcare representative document, or sometimes called a healthcare proxy. I think some states actually call it a medical power of attorney. A lot of times, if I use that term, most people understand kind of what I'm talking about. Certainly, a last will and testament is involved. And for some people, some situations, perhaps a trust is necessary or could be a good planning tool for them. But regardless, I think a lot of people think of estate planning and they think of the first thing they think of is, I better get a will. Well, okay, that's true. That's probably a good start, but I would actually back up and start a little bit in front of that. And those first three documents there, the power of attorney, the living will declaration, the appointed healthcare representative, those would be my foundation, so to speak. What we're going to find out is we're going to go through each of these documents in a little more detail, kind of compare and contrast some variations of them, kind of describe what they do for you, what kind of considerations you want to make when you're thinking about who you should put in these various roles that would potentially serve you. Because I think that's probably one of the more important components. I like to say estate planning is not a complicated thing. People and personalities, however, can be rather complicated. So that's the key, is always getting people in the right place. So before I jump into each of these documents, I'm going to give just a general overview, some basic estate planning tips. And then we're going to talk about, whether or not you need these documents. If you've got old ones, should you review them? Then we're going to go through the details of each. So hopefully, if you can see my screen, you see my joke here. Hopefully you can see the joke here. The picture says, "Don't believe everything you read on the internet," a quote from Bob Dylan, the drummer from the band Metallica. Yet, this is a picture of the artist formerly known as Prince, right? This is a different musician entirely. Bob Dylan never was a drummer that I know of, and he certainly was not with the band Metallica. So the point being, you can get out there, just like anything, any topic, whether it's estate planning or anything else, you could get on the internet and start Googling things, and it's hard to say what you might find. It's a very frustrating thing for me when I've got clients that walk in the door and they're terrified. They said, "Oh my gosh, Justin, I read on the internet that XYZ will happen if I do A, B, and C." And a lot of times it's misinformation. And so one of the big things is, these are just some general estate planning tips, having a plan. So what do we mean by that? Well, we're going to hopefully identify some of the things that might need to be involved in that plan. So having that particular plan is going to be a really important component. Every plan may look, no two plans are going to look totally identical. Each family, each household, each individual is going to have a different set of goals and priorities. Each household is going to have different concerns, a different mindset, different philosophies on things. That's okay. That's what makes us all interesting as people, is that we are different. So each of our plans may look a little different than the neighbors. So if you hear your friends down at the coffee shop or the next door neighbor saying, "Well, you need to do this because blah, blah, blah." Well, maybe their situation's a little different than yours. So you got to be careful when you take that coffee shop advice, right? Whether it be with estate planning or, fixing your car or whatever it might be. So having a plan, discussing the plan. What do we mean by discussing the plan? Well, that means don't be afraid to talk about it. Well, who do I want to talk about it with, Justin? Well, I would say obviously your estate planning attorney, your immediate family that's going to be potentially involved or impacted by your plan. If you have a financial advisor, they should be at the table as well. Perhaps if you have a tax preparer or CPA, it would be very good to get input from them. So those are that's just a short list of the people that I would want to involve in the discussion. I think one of the hardest parts about estate planning is that people are afraid. It's not a fun, easy thing to talk about. It's not one of those things that we jump out of bed and say, "Let's talk about my will." It's not one of those things that people just get overjoyed to think about or talk about. It's terrifying in some ways. And so even being brave enough to initiate that conversation is probably the first big step that anybody can take. Then trying to make yourself comfortable enough to be willing to have the conversation with those around you. That's really important. As I mentioned a few minutes ago, My joke, Jenny, my wife, always says I'm full of dumb comments and jokes. She's probably right. Estate planning is not a complicated thing. People and personalities certainly can be complicated. So making sure we get the right people in the right role, that's going to be integral, very important for any estate plan. Those of you that are retired teachers, how many times did you tell your students there's no such thing as a dumb question? Now, I know that we all know this. If you were in the classroom, every now and then you had a couple students that did ask some dumb questions, but we didn't want to tell them that. When it comes to estate planning, when it comes to talking to your estate planning attorney as you're going through this process of getting a plan created, you need to ask the questions. If one of the personal goals I have is when a client leaves our office, I want them to understand how this plan works, what it's going to do for them. I'm not going to say I have 100% success rate in that, but I will say that we try very hard to make sure that we can explain things in a way that they understand it. And if the client's not willing to ask questions, and if they don't stop me in my tracks and say, Justin, you're going to need to explain this again. I'm not following what you just tried to tell me, then I won't know. I won't know that they don't know. So please help those around you by asking questions if you're uncertain as to what the individuals are talking about or what they mean by the certain planning tools. Okay, then the lawyer part of me is going to say this next point: put it in writing. The best of intentions are nothing but intentions unless you properly formalize them. For example, specific things like a power of attorney. Was it notarized? A last will and testament. Did it have two uninterested witnesses signed? Did it have a self-proving affidavit, which states that you're of sound mind, et cetera, et cetera? Is it properly formalized and executed and in writing? If it's not, then it's not good. It's not going to hold any water. It's not valid. And of course, the one that I led with is actually the last bullet here. Don't believe the misinformation. You can get online. You can find all kinds of information, whether it's accurate or not. Who knows? But talk to somebody who does this stuff every day that can steer you down the right path and alleviate some of those concerns where you scare the heck out of yourself. Just like, if you're not feeling good one day, you get on old Dr. Google. Next thing you know, you've got every ailment there's ever been, and you're totally stressed out. We don't need that. So be cautious with what you find online. So just after those general tips, as we go through each of these documents, I want you to reflect a little bit. I want you to ask yourself, do you have these documents that I'm going to go through in detail? And then I'm going to ask you, well, some of you may say, yeah, I've got these. Some of you may say, nope, I put it off a while. Maybe this is the time to start the process, get the conversation started. But others, if you do have these things, it's not uncommon. I've heard many people over the years say, hey, Justin, yeah, spouse and I, we did a will, but it was when the kids were young. We just wanted to make sure they had a guardian in case something terrible happened. And guess what? Those kids now have their own kids, and we want to reevaluate our situation. We don't need to worry about guardians anymore, but maybe we need to worry about setting up something for those grandkids or, whatever. Our situations are always going to change. If your situation changes, I should say, when your situation changes, your estate plan should be able to adjust with those changing circumstances and times. So if you have some of these documents in place, reflect a little bit if you can. Ask yourself if your documents are current. And what I mean by that is, do they currently meet your needs? One of the jokes we had, Jenny, my wife, always joked about the fact that her parents did a will many, many, many years ago when she and her sister were young. And the big thing in there was the guardians for Jenny and her sister. Well, lo and behold, my in-laws haven't updated their plan until just a handful of years ago, and our office helped them do that. And the joke was that the old wills that my mother-in-law and father-in-law had named guardians for Jenny and her sister. But about a year after they got that will signed, the people they picked as guardians moved out of state and then later got divorced. And they never bothered to update things. Well, for many reasons, it's a good thing we didn't have to rely on the guardianship language, obviously. But had they, needed to rely on that, you can imagine the mess that would have ensued. So always making sure things are updated. Another point of emphasis here, every now and then we'll run into somebody that they don't update things, and maybe they have a life insurance policy or an IRA that lists an ex-spouse as the primary beneficiary. you want to talk about awkward conversation when we're reviewing things. So just always take a little time to reflect on that and review those things. So without anything further, let's go into the various estate planning documents. Let's dive through these. Like I said, I'm going to try to hit some of the main highlights, try to explain a little bit about these documents, what they do, maybe some of the variations of them, why they might be important. And then I want to leave a little time. So if you did post some questions in the chat, we can address those. Maybe if we leave a little other time for some Q&A, we can get that taken care of as well. So let's start with a power of attorney. What the heck is a power of attorney? So when I think of a power of attorney, think of it as the individual that I can appoint for myself to basically like make legal and financial decisions on my behalf. In other words, they could sign my name on a deed. They could sign my name on a check. They could do all those different things as it pertains to legal and financial matters. So when we think about this, my golly, think about the level of authority and authorization you give these individuals. That's pretty important. You could think about how the situation could be pretty disastrous if we've named someone in this role that's not very organized, that is maybe not very honest and trustworthy, perhaps someone that is easily tempted to take advantage of the situation. That could be a gigantic problem for us. So again, when I'm sitting down with individuals and families, the first time I meet them at one of our consultations, I want to know about their family. I want to know about the people involved. Well, maybe they don't have kids. Who are their close friends? Who are the siblings or relatives that they're close with? I want to know about their personalities. Tell me about their skill sets. If you go over to their house, do they have that stack of past due utility bills on their kitchen counter? If that's the situation, I probably don't want that individual making financial decisions on my behalf if I ever needed them to. You can imagine how disastrous that could be. So, when it comes to deciding who's going to serve in this role, I like to use what I'm going to call it the checkbook test. What I mean by that is if I had a full book of checks that were for my account, they were all blank, and I signed every single one of those and handed those blank signed checks to somebody else, can I trust that person? Are they going to use those checks to pay my light bill? Are they going to use those checks to pay my insurance premiums? Are they going to use those checks to sign everything over to themselves because they were behind on their own utility bills and insurance premiums? Those are the tests I want to kind of play around in my mind to determine if this is the right person or the right people to serve in this role. Because, most of the time you get a pretty good feel for that. You probably have a pretty good idea of who you'd want in this role. A lot of times spouses pick one another. That doesn't mean you have to, but most of the time that's the case. However, when it comes to, that a lot of times is the easy decision. But when we're building an estate plan, not only do I want to name the primary decision maker, but I want to go ahead, if I'm going to build a comprehensive estate plan, I want to build the backups in now. I want to go ahead and say, okay, if my first choice is unavailable, perhaps they've passed away. Perhaps they are, moved away. Perhaps they're nowhere to be found. Whatever the situation, I want to have a backup plan already there so that that next person can be elevated to the front and have that authority at that time. Now, a question I often get, do the backup people have any authority? The answer is not until they need to. So they would not have authority unless it is proven that the initial power of attorney is unable to act on your behalf. So I'm going to take a pause and describe a couple different categories of power of attorney because I hear a little bit of feedback and people ask me, when does this become effective? So there's two general categories for a power of attorney document. There is what we call a springing power of attorney, and there is what's called a durable power of attorney. I'm going to go ahead and tell you right away, I have a preference towards the durable power of attorney because it is effective immediately. As soon as the ink dries, that document is valid. Whoever I've given that authority to has the authority to act on my behalf immediately. That's a durable power of attorney. A springing power of attorney is going to mean it springs into action upon some event. The event that I'm referring to is usually described within the document itself. Maybe on I'm just going to make up a really facetious example. Maybe it says, the power of attorney is only effective if 32 doctors have declared in writing that I'm unable to make my own decisions and I'm incapacitated. Now, that would be extreme. However, maybe it says one physician has said that I'm incapacitated. Maybe it says something else. I don't know. Maybe it would say something bizarre like on my 112th birthday, now it's effective. That would be a little bit weird too, but I guess you could put that in if you wanted to. The reason, though, I'm not a big fan of a springing power of attorney is simply because if I need this person to act and we have to wait for those 32 doctors to sign off on it, or we need to do X, Y, Z, jump through all these extra hoops in the 11th hour, I've potentially set myself up for a lot of added delay, headache, and inability for this person to act on my behalf when I need them to act on my behalf. So I think of a couple scenarios that kind of drive this point home. There were times when my maternal grandfather, who suffered from Alzheimer's disease, who was a former educator himself and school administrator, there were times when during his illness, he could fool people. He could fake it really well. He was very good at just carrying on a conversation. He probably didn't remember the conversation a few minutes later, but he could make people believe he was tracking what you were talking about. In the same breath, I'm also going to say he had no business at a certain stage in his illness that he should not have been holding a checkbook. If I had to wait for a doctor to sign off on saying that he was incapacitated, we may have the makings of a disaster on our hands until we finally get that approved. Doctors don't just love to go around and declare people incapacitated. They want to make absolutely certain that that's the case, because if you're doing that, you're kind of saying this person doesn't deserve to have the same rights as they previously did, and they shouldn't make their own decisions. Doctors don't like doing that. Nobody likes doing that. So they want to make absolutely certain. So I see a lot of potential issues with the springing power of attorney. If I trust the person that I'm giving this power to, if I know they're going to pass my quote checkbook test, then I shouldn't have any reservations about using a durable power of attorney. If I get the right people in the right role from the beginning, then it shouldn't be a problem. Okay. So with that being said, two more components or two more points of emphasis with a POA, as we sometimes call it. In a power of attorney document, you also can name guardians for yourself. Or if you're a young family, you can name guardians for a minor child in your power of attorney document. A lot of times people, young families think they need a will so that it says, well, if I pass away, who's going to be the guardian of my child? Oh, that makes sense. But what if I'm in an accident and I'm incapacitated either permanently or temporarily? In the power of attorney document, it's going to name who I can select who would be a guardian of my child, even if it's in a temporary situation while I recover, because we don't really invoke a will unless someone's actually deceased. So a lot of time, I always say, tell that to your younger family members that it's important to make sure they've got that in their own planning documents. Now, one of the other misconceptions with the power of attorney, they do actually end when someone passes away. If you are alive, you can have power of attorney. But once I've passed away, the power of attorney expires. The person that I've named as having that authority no longer has that authority. We'll see this happen from time to time where someone calls the office. They say, Justin, my mother passed away. I'm her power of attorney. What do I do? And my answer is going to be, you can't do anything, at least not in this role. Maybe you are also the executor or executrix of her will. Well, maybe you're still able to act, but just in a different role. You're wearing a different hat at this point in the game. So again, they do expire when someone passes, where it becomes a source of frustration for families. Sometimes they'll go to the bank, they will present the power of attorney, and they will say, Mom has just passed. I need to help consolidate funds. They're going to say, sorry, can't do it. We're now freezing the account. You don't have the authority. And they're appropriate to do that. That would be the way that should be handled. There are steps that can be taken within your own planning to prevent that delay in freezing the accounts. But maybe we'll touch on that here a little bit this afternoon. So if you've got some questions on that, certainly if you can, feel free to enter those in the chat. I do want to leave a little time to make sure that we can get to those questions, but I'm going to keep moving in the interest of time so that we can get through the rest of the material. The next document that we're going to touch on is a living will declaration, which is very closely tied to my next slide, the healthcare proxy, because actually we incorporate both of these documents now into one document. We didn't used to. There was a minor technicality in the laws that changed, which allowed us to do this a little more freely. So we incorporate the living will declaration with the healthcare proxy. Don't worry, if you've got two separate documents that outline those things, you're fine. It was incorporated and grandfathered in. But what does a living will declaration do? I get some people that, again, the misinformation on the internet, or just maybe misusing terminology when you're having breakfast and you hear your folks at the next table talking about their situation. The living will declaration is very strictly tied to artificially supplied hydration and nutrition, AKA a feeding tube. The living will declaration is essentially saying, in the event that my doctor has put it in writing that my passing will occur within a short period of time, efforts could be taken to prolong this process of me passing away, which would involve giving me artificial hydration and nutrition. However, these efforts will not ultimately save my life. I hereby direct my healthcare representative to do one of the following three things. Either yes, provide me artificially supplied hydration and nutrition, AKA the feeding tube, even if the effort to sustain my life is futile or burdensome. I could also say, or in contrast, I could say, I hereby direct my healthcare representative not to give me artificially hydration and nutrition because the effort to sustain my life is futile or burdensome. Or the third choice is I intentionally make no decision. Basically, whatever my healthcare representative decides on this topic, I will give it my blessing. Now, this is the world's worst multiple choice quiz. Those of you that gave those multiple choice quizzes, you think about some of those. This is a pretty heavy one. This is a difficult choice. There's no right or wrong answer on this one, however. It's got to be what gives you the most peace of mind. But I think just as much as anything else, what's going to give your family the most peace of mind. If I'm going to pick one of these first two options, then I've taken the decision off of the shoulders of someone else. I've at least allowed them to read my instructions and say, okay, this is what Justin wants me to do. I'm going to put my head on the pillow at night for many years to come. And all I'm going to do is say, he asked me to do this. This is what I'm doing. If I pick the third one, understand that there's some weight you're putting on somebody else's shoulders. Basically, you're saying, hey, this one's on you. You figure it out. And I've had some clients say that's okay. They're strong enough to handle that decision. That's why I picked them as my healthcare representative. I know they can make a strong decision and they'll live with it and they'll be fine. You know your people more than I do, and whether or not that's true or not. I would just say tread with caution on this, because whatever decision you do make, if you pick one of those first two, yeah, you've taken a decision off the shoulders of someone else. If you pick the third one, maybe you do think that the person that you've put in the decision maker's chair can handle it, but you're still putting a lot on their shoulders. So again, the living will has to do very specifically with artificially supplied hydration and nutrition. It is incorporated into the healthcare proxy document now. For a lot of attorneys will do that. We do that as well. But at the end of the day, you're giving guidance for what you would ask someone to do on your behalf if the situation is very extreme and very dire. And again, this only has to do with artificially supplied hydration and nutrition. It does not mean a do not resuscitate order. It does not mean to withhold CPR. Those are what we call advanced directives. Those advanced directives are listed specifically. What advanced directives authorization you give would be in basically the bulk of the content of the appointed healthcare representative document, which we nickname sometimes a healthcare proxy. And again, the healthcare proxy, appointed healthcare representative, medical power of attorney, whichever term you like in whichever state you might live in, basically it means who is my medical and healthcare decision maker if I can't do it for myself. Now, understand on this one, if I'm perfectly fine, they're not going to listen to my healthcare proxy. They're going to listen to what I have to say. However, if I'm unable to make the decisions or communicate my decisions on my own behalf, this is who I've nominated ahead of time to actually make these decisions for me, whether it be for treatment decisions, making decisions on those advanced directives, whether or not that my healthcare proxy has been authorized in the document to issue do not resuscitate on my medical chart, all these different things that you can give that authority to. So when I think about someone that would serve in this role, I want someone that's pretty strong. I want someone that can handle some stressful times. I want someone that can kind of, clear the fog from the emotions, set that off to the side and say, I'm going to get back to the emotions later. But right now I've got to think clearly. I've got to make sound decisions on behalf of Justin or whomever they're making decisions for, assess the situation, be able to hopefully understand what the healthcare professionals are saying to them and analyze that and make a good informed decision on your behalf. Difficult role to be in. Again, spouses, oftentimes are going to pick each other in this role. Maybe I don't have a spouse. Okay, so I want to be thinking about who I trust to be able to potentially make some difficult decisions on my behalf. If I do pick a spouse or whoever my first choice is, I also want to be thinking about who my backups are. And let's go ahead and build those in ahead of time so that we've got a good comprehensive plan right from the start. So, again, thinking about the skill sets, the mentality, the skills of the individuals in this role, think about, are they strong enough to handle some very difficult decisions? Are they afraid to let go? Are they going to be, I've got two sisters. One of them's pretty blunt to the point. The other one would be in the corner sobbing and crying, unable to make a decision because she's inconsolable. I don't want someone like that for me. So those are things that I think are important to consider. Like I said, getting the right people in the right role. Now, those three documents are certainly, I would say, the most important estate planning documents. Like I said, most people are often thinking estate plans are about the whole question of who gets what when I'm gone. These are the documents that can impact you during your lifetime. So that's why they're going to be the building blocks for all things when it comes to planning. Now, what most people think about with an estate plan is my will. Okay, so what does a will, first of all, what does a will actually do? The same thing here I'm going to start with is making sure the person is able to manage things. Whoever I've named as an executor or executrix, which we technically call the personal representative of the estate, that's the person in charge of administering my estate, at least the estate that's governed by the will. I want someone that's got some organizational skills. Can they take inventories? Can they also be strong enough to tell the other beneficiaries to back off for a little bit until we get things ready? Quit calling me every day asking for your money because we've got a process we've got to follow. Are they able to do those things? A lot of times people that serve in the role as an executor or an executrix, there's work to be done. And if some of you have walked in those shoes, you understand there can be a lot that goes into this. And most of the time, people that serve in this role, they're doing it during their working years. And there's just sometimes a lot on their plate. So it can be a challenge to get things organized, get things done. But let me actually back up a step. What does a will actually do? And a lot of people are going to say, well, it determines who gets my stuff. And I'm going to give you my first lawyer answer of the day. And I'm going to say, well, actually, that depends. I'm going to ask the first question of what is the asset? And the second question, how is the asset owned? Because a will governs the distribution of assets of a deceased person if that asset was owned only in the name of the deceased person and if that asset did not have a designated beneficiary. So again, think of it this way. Asset owned by one human being, the deceased person, and the asset did not have a designated beneficiary. So if I've got an IRA, a life insurance policy with a beneficiary designation, I could have written in my will that I give that IRA or that life insurance policy to Mickey Mouse. And if Mickey Mouse is not that designated beneficiary, well, I hate to break it to Mickey, he's not getting the money. It's the designated beneficiary that's going to supersede what's in a will. So a beneficiary designation the will doesn't matter. If the property is jointly owned with a spouse or anybody else that has an automatic right of survivorship, again, the will is not going to govern that because the joint owner, if they have the right of survivorship, is automatically going to retain ownership rights, despite what a will might say. And obviously, it's really confusing if the will contradicts the joint ownership, and then it's just a mess you have to explain to everybody. But the will governs anything owned by one human being if it doesn't have a beneficiary. So if I have a trust that I've set up, maybe I have a living trust, whether it be a revocable living trust, whether I have an irrevocable living trust, whatever it may be, and if the asset has rightfully been transferred or retitled to that trust, the will is not going to matter. The trust documents would matter. So there's a whole dynamic. That's why I say the question of how the asset is owned is incredibly important. So that's why it's got the bullet point. Controls only assets held in your name at your passing, and if that asset didn't have a beneficiary. The other things the will is going to do is appoint who and name who's in charge, the executor or executrix, who's in charge of the administering of the estate. But the thing of it is, technically under the law, that person doesn't have a lot of authority or control until the judge says so. So when we have to administer an estate, we are required by law to go through this process known as probate court. And I've got just a quick run through on probate. Don't worry about this part of it, but just to give you an idea, some of you may have been through this with a loved one of your own. The probate process is a court process, basically. And here's my former teacher being cynical towards attorneys. The law in Indiana says if we go through this process, you are required by law to hire an attorney. Now, if we could just get the teachers, if we could just get that strong of a lobby, just like the lawyers do, maybe we could change some things for the better in education, but we don't have enough hours in the day to solve some of those problems. But maybe that'd be a good little sidebar conversation for us all. Pardon me. So when we go through this process, you are required by law to go through a court system. The executor does not even have authority until the court issues what are called letters testamentary. That's the magic golden ticket, if you will, that lets the executor go to the bank and quote, I'm going to say unfreeze the accounts to actually have legal access to the accounts and the finances and everything to start consolidating things, start getting things organized. Because prior to the court issuing those letters testamentary, the accounts will be frozen. Once this is all starting to take place, you're required by law to provide notice to a lot of different people. That's what it says, notice provided to, and then there's nothing after it. All basically think of it as interested parties, the named beneficiaries, spouses, children, even if they're not specifically named in the will, creditors. Okay, so if we have a known debt that the deceased person had, mortgage, whatever it may be, we're required, if we know about it, to send them notice that the person has passed away, serve them written notice that there's a probate action that's pending in a court. So that starts the clock for what we call the creditor claim period. So it can become the hurry up and wait game. You get all this paperwork filed, you get things out, you send all these notices, you have the notices that run in the newspaper that say, hey, everybody, Justin passed away. His estate is in whatever court, here's the cause number in the court. And then you start this clock ticking to allow 3 months for any creditor to file a legitimate claim against the estate if I owed them money. Again, like I said, you give beneficiaries the notice as well. Once the claim period is run, once we get some of these, all the bills paid, once we do all these things, then the executor can start to clean things up. Only then would we, once we know we've paid all the people that need to be paid, then we would say it's okay to start distributing assets, even though we'd want to leave a little bit behind to file a final tax return for the individual and pay those fees associated with filing those taxes. And then we can finally get to the point where we close the estate. In a smooth situation where people aren't fighting and it's pretty cut and dry, I'm still saying that you might be lucky to get an estate open and closed within 5 to 7 months. I think you're going to be more likely to see closer to 9 to 12 months. And that's just because executors have a lot going on. There's a lot of things that could be at play here. So we want to make sure that this takes some time. And then once we get through all that, we can finally close the estate. So that's just a real brief thing about the probate process. When we are administering a will, you do have to go through that process. So I mentioned a will governs something owned by one human being if that asset doesn't have a beneficiary. Well, some people out there, you may have or have heard of a trust. We have got a couple subcategories of trusts. I'm not going to spend all day on these, but just introduce the terms. But before I do, think of it this way. If I have a trust and I have retitled assets to the trust, I'm going to use the word funding the trust. So what is funding? Funding means I've retitled the asset. So it's not owned in my name anymore. It's owned in the name of my trust. A trust is not a person. Okay, a trust is not a human being. So when the human being that set the trust up passed away, the trust still owns the property. The will in other words, doesn't matter. It means we don't have to go through the probate process because the trust rules, whatever custom rules that we put in this trust, are going to determine what happens to these assets after I'm gone. So trusts serve a couple, several different roles, but for a lot of people, their goal is avoiding that entire probate process that I just described. For others, they set up a very specific type of trust called an irrevocable trust, which can be used to protect assets against, long-term care costs that we're worried about, potential creditors, potential predators that might try to take advantage of people and use scams and so forth, because there's some restrictions and limitations when you use an irrevocable trust. Don't worry, I'll get to that with the next slide. But, a couple different categories here of these trusts that I'm going to talk about. There's a living trust, and then there's a testamentary trust. There's also a revocable trust and an irrevocable trust, which will be on the next slide. The lawyers are really good at complicating the obvious, and many of you probably already thought that. Every now and then, a lot of times we'll use words that we kind of just either pull from old Latin phrases, and then we try to act like we're important, that we're the only ones that know what they mean. That's just called job security for us because we have to explain these old terms. But every now and then we actually use a term that makes sense. So when we use the word living trust, all it means is it's a trust that I created while I was alive. And for once, we actually use a term that's logical and makes sense. So these are a lot more efficient. This is a really good tool to avoid probate because if the trust owns my property, my family doesn't have to wait the 3-month creditor period. We don't have to go in front of a judge. We don't have to do all these different things and have all that extra time and expense to administer my estate because the trust is a private document. We just read what the trust says to do and we administer according to those terms. So it's a very good tool to avoid probate and make things a little easier that way. It's also easier, I'm going to get to talking a little bit about how you can customize the terms of how things are distributed. Much easier to do with a trust than it is with a will or even with just beneficiary designations. But the living trust basically means I set it up while I was alive. And again, it's not worth a whole heck of a lot if I never fund it. If I never get assets retitled to the trust, I'm not sure what good I actually did. So we need to make sure that's a key part of it. We have actually a part of our team is dedicated to helping the client get those assets retitled and get them funded into the trust because we kind of think our reputation is on the line. If we say, here's the trust, and then you walk out the door and nothing ever gets done to get the assets retitled. We kind of like to have our own peace of mind knowing we actually helped complete the project and get the assets retitled. So living trust, very common estate planning tools. Testamentary trusts basically just means they're built into the last will and testament. They're not created during your lifetime. They're only created after you pass away when the will kicks into action. Those are probably a little more common with younger families. They want to make sure if there's funds going to a minor child, they have some controls around it because a living trust is probably going to be, and most of the time it's going to be much more expensive, well, at least a little bit more expensive to set up than a testamentary trust. So younger families, they say, well, I don't want to have that expense right now, but in the worst case scenario that we untimely passed away, let's have some custom rules so that we know that a 12-year-old is not going to get a pile of money in their lap. So those are things that we want to make sure we kind of describe what they are. So then the other two big categories for trust, comparing these two, would be a revocable trust or revocable, whichever way you like to pronounce it, and an irrevocable or irrevocable trust. Again, the revocable trust is a phenomenal planning tool to avoid probate. Okay, makes it a much more efficient means to administer someone's estate because we're not going through court. It's also a great tool to customize how assets are distributed. I think if I've got several parts of real estate, it's a very good planning tool, especially if I've got real estate in multiple states, which maybe somebody has a place in Arizona or Florida, whatever. I can potentially not only avoid probate in Indiana, but also the state where that other property exists, because if the trust owns it, it's a very efficient means to distribute my assets that way. But again, I could have incredibly customized plans. I could say, you know what, maybe my daughter is a wonderful person, but she's not a very good money manager. If I just make my daughter the designated beneficiary of my IRA or life insurance, when I'm gone, she fills out a couple claim forms. Those assets are hers, and she does whatever she wants. If she blows it within a year, so be it. If I have a trust, what I can do is I can put some pretty customized terms that say, look, love my daughter to death. My goal is to make sure that the funds are there to help take care of her the rest of the life. So maybe we have some restrictions. Maybe it says she gets so much a year. Maybe it says she gets so much a month until the money's gone. Or maybe it's so much a year until she's age whatever. And then you can have the rest of it because hopefully by then you're mature enough to manage it. You can build in all these what ifs. My joke usually with clients is we're going to say that, my beneficiaries in my trust, they only get their $5 a week if they come to my final resting spot, sing my favorite song, go down this whole list of things, and then the trustee's going to hand them a check. Well, that would be a little extreme, but the point being, I can do all these different things. If I just name them as a beneficiary, well, I hope they don't blow it, because I think I read an article, they always, these articles that come out, one of them recently said that the average inheritance is spent like within 18 months or something like that, and it's all gone. So sometimes there's a need to have a few parameters around some of these things. So revocable trusts, very good tools for that. Irrevocable trusts or irrevocable trusts are very good planning tools as well. Again, they also will avoid that whole probate process. They still would allow you to customize how things are distributed if that's a need of yours. Again, maybe it's not, and that's okay. But some people, maybe they need to have some controls on how things are divvied up, and maybe a little bit over time instead of all at once. But the other thing the irrevocable trust does is it's going to provide asset protection. In other words, the big thing that people call our office for, and they're interested in learning more about with irrevocable trust, is the fact they say, look, I heard you guys are estate planners, but you also do what we call elder law, which means we're trying to help navigate through the fears of long-term care. I worked really hard. I lived within my means. I saved. I've got, I was within a budget. I've got a little bit accumulated. I want to make sure that I don't have to write a check for $10,000 a month for my long-term care, because my goal was to have some kind of a legacy plan to make it a little easier on my surviving spouse, make it easier on the next generation, and have something set aside for them. How do I protect these assets? Well, I can use an irrevocable trust and put certain assets within this irrevocable trust. And now I'm actually protecting against these concerns. So we call them long-term care costs, against personal liability, against those predators that are going to possibly, try to take advantage of someone as maybe they're aging and they're easy targets, unfortunately. The good news about some of the irrevocable trusts that are able to be designed in this day and age, and in the last probably couple decades, is there are types of irrevocable trusts where you are still allowed to be the trustee. You're still allowed to be in charge of the trust. Now, there are types of I call them the old school irrevocable trusts, where they required that you name someone else as the trustee. You couldn't even be the trustee of your own stuff and your own trust. The type of irrevocable trust I like still allows you to be in charge. So let's pause for a minute and talk about what is a trustee. So a trustee is going to be the individual that manages the trust. So if it's my trust, I want to be the trustee. It's my stuff that I put in there, that I retitled to it. I want to be the one that makes the decisions for how the money within the trust account is invested. Is it in certain mutual funds? I call the financial advisor, say, hey, I want to talk about the trust that I'm the trustee of, my stuff. And I want to make sure that we have it invested this way, that way, or whatever. So I'm still in charge. I manage the assets owned by the trust. Now, I'm also going to have instructions in here that says, okay, if I can't be the trustee anymore, who's my successor? Who is the successor trustee? And the successor trustee still is in charge of managing things, but they have to manage things in a way that is in the best interest of all the trust beneficiaries. They can't go back and change my terms. They can't go back and say, okay, Justin's incapacitated. Let's rewrite the terms of this trust and change it so everything comes to me and not these other people that are the named beneficiaries. They're going to get in a lot of trouble if they did something silly like that. So again, though, you can see skill set. Who do I want as my successor trustee? Well, someone that's organized, someone that's pretty well read when it comes to managing things, someone that's got integrity and honesty, which should always be common sense, but sometimes you still have to go through and talk about that just to remind people of it. So again, when I say trustee, think of that person as the manager of the trust. Their job's to oversee it, make sure things are done the way that they were supposed to, make sure that they're following the rules that way. I tried to talk quickly. I wanted to leave a little time for some Q&A. My formatting got a little off here, but we talked about a power of attorney, a living will, a healthcare proxy, last will and testament, as well as a trust. This is pretty much what we do every day. We stick to estate planning. We stick to elder law. We do a few other things. Certainly, if you've got questions about some of those other things, this is pretty much what you see on the screen. Estate planning and the things on the screen is pretty much what we do. If you ask me to help your cousin with their latest divorce or bankruptcy, I would throw up my hands and say, I have no idea. I wouldn't want to start today. We kind of stay in our lane. I'm going to stick around for some Q&A. I like the idea that the way we do things, it's kind of low pressure. You don't have to pay to sit down to talk the first time. It's one of those, I want to truly get to know you. We want our other attorneys and our other team members to spend time to really get to know you, your dynamic, what's going on. I want you to open up to us so that we can help give you the direction and get you down the path that we think is going to do the best for you as it pertains to building your own estate plan. So we can accommodate wherever you're at in the state. Certainly, we can do our best to accommodate you because we can do some things remotely. But like I said, we don't charge you to sit down. We do everything on a flat fee basis anyway. So that way, you're not afraid to call with follow-up questions later. So there's our contact information there. Make sure I get this figured out so I don't screw up. Stop my sharing and see where I'm at on this to make sure that we've got, okay. If you have some questions, I'm going to try my best to not mess up the question and answer screen if I can find where I just minimize that. So if you do have some questions, feel free to shoot those over to me. Looking for those. I'm looking here to make sure I lost my screen to see where the activity log or the log to see if any questions are being posted. Yes, I can. Sure. Thanks for I knew I'd mess up on the technology somewhere. I had that screen earlier where it had all the chat, and I'm looking like a crazy person trying to find it, I'm sure, and I can't see it. So great question, Charles. Can I name more than one person as the power of attorney? The initial answer, yes, I absolutely can. So I can actually go a little further than that, and I can say, look, I'm going to name co-POAs, maybe two people. I could have three. I always am going to say, let's be careful not to get, quote, too many cooks in the kitchen. We don't want that because the more people you add to the mix, certainly the more potential for some kind of conflict where they're going to butt heads. And especially if I'm thinking about naming my kids in this role, I'm going to always ask people, those of you that have kids, raise your hand if you've ever seen them argue. Have you ever seen them disagree? So you just have to tread with a little caution there. One of the disadvantages that you could have is if you name co-power of attorneys, one of the things you might realize is do we want to build in some flexibility and kind of say either or, either of these two people can act on my behalf? Because if you say it's just co-power of attorney, then it may be a little inefficient if I need both of them to always stop what they're doing to come here and sign off on stuff. Now, you could look at that two ways. That's good because it allows a little bit more transparency that we know that it takes two of them to sign off, but it might slow things down if I need some action to be taken quickly. So the answer, yeah, you can name co-power of attorneys. You can name co-healthcare proxies. You can name, again, more than one person as an executor or as a trustee. But there's risks and rewards with this. You just always have to be careful that you don't set things up in a way that's going to lead us down a path where there's some conflict between them, because that can make an already stressful situation a lot worse. So I hope that helped. Wonderful question. And they actually just changed a rule on this in July of 2022. So remember when I said estates go through probate if the asset's owned by one human being and if the asset did not have a designated beneficiary. Now the probate rules might apply. So when do I have to go through a real, true, formal probate process? It's if the collective value of all assets that were in that one person's name, and again, if they didn't have those beneficiaries, if the collective value of all that stuff exceeds $100,000, now I am required by state law. My family has to go through this process. If it's under $100,000, there's a lot less restrictive ways to get things facilitated. You can use these, we call them small estate affidavits, which basically say, okay, we hereby sign, we promise that Justin's estate was under 100,000 based on his estate plan, his will, or whatever it was. These are the appropriate heirs of this bank account or whatever it may be. And that's the way that those can be managed. The threshold, the dollar amount threshold that we're referencing, that's 100,000, actually used to be 50,000, and they just changed that and increased it July 1st of 2022. So that's a very recent change in the law. So it depends, right? This where it comes down so much to the dynamic of the people involved. Who are they? What are their skill sets? Maybe it's one of those things where there's so many different things at play that it's just, you just want to have the talk with the individual client. Because what if I've got two kids, one of them lives, three houses down, the other one lives out in Arizona. Well, to me, I'm thinking if I want to have the Arizona child on here as a co-trustee, it's going to be kind of inefficient to administer things. The one that's right here, maybe they're the best suited, but then again, maybe you say they've got no organizational skills. Unfortunately, there's just so many variables at play here that it's hard to just give a blanket statement as, to say, what are my thoughts on it? Because everybody's household's a little unique. Most of the time, I say this optimistically, most of the time we've not seen terrible experiences with it, but we just want to know a little bit more about who are the players here. Let's get to know more about them. One thing I do want to point out, it makes me think of something. How many times I'll have people say, well, I want to name co-power of attorney and make both my kids the successor or the current co-power of attorney. I want to make both my kids the co-trustees because if one of them's named and the other one's not, then they're going to feel like their feelings are hurt. And that may be a little bit true, but I'm also going to say this: you need to be selfish when it comes to this. It sounds kind of blunt to say it, but I'd rather you say, let's get the right people in the right seat on this bus, because I don't want to put somebody in a role that's going to do more harm than good just because I don't want to hurt their feelings. This is about making sure my plan is going to be carried out the way I need it to be carried out. So it's sometimes a little harsh to come to that realization, and not everybody takes my advice, don't get me wrong, but I sometimes will say you need to reflect on that. You need to think about that and make those decisions based on those factors. Yeah, so we got a couple locations. I'm in Fishers today, but we also have an office in Rockville, Indiana, the west central part of the state, also in Wabash, Indiana. I used to teach up in Wabash County for 6 years, so that's part of the reason we're up there. So I have that community has a nice place in my heart. But so we're in a couple different sections of the state. But we've helped clients all the way down on the Ohio River because we're able to do things through Zoom and maybe not have to do quite as much in person. So yeah, we've got some options there. But those are the physical locations. If you're over 18, even if you're over 18, I think it would be a good idea to get a power of attorney and a healthcare proxy because technically you're a legal adult and mom and dad can't make decisions for you anymore. So if you know, fell down unfortunately you hear about it, had an accident while you're off at college or this, that, and the other, they can't act for you without some of these documents. So 18 would be the starting point. But as far as like thinking about more in-depth things, certainly think about getting a will as soon as you start a family, making sure you have guardianship language for minor children. And as you start to think about, as you approach some of these other changes in your life, whether it's moving, changing careers, retirement, those would be the times when it's probably a good idea to at least consider some of those other options. Maybe a trust is a good decision for you, or maybe it's not. That's just, everybody's a little bit unique and depending on their specific situation. But like I said, maybe as you start approaching retirement, it's a good time to really have that conversation. I appreciate it. We thank you for having us. I just had a blast. We were able to do that this past September, I think it was, when we were going around some different parts. Got to meet some tremendous people. Got to hear a lot of funny stories from some former educators, and we appreciate the fact that you've included us. And I hope, like I said, I hope people could get some information that was beneficial and useful for them. So I hope everybody enjoys this lovely snowy afternoon and stay safe out there. Okay, thanks again.